Dear students, we are back at Industrial Property Law HOE 6065, and I was looking at trademarks last time, Article 5. So we spent some more time on that, just look at some aspects about it and some important case laws in this regard, because they will be really helpful in the later chapters also when we talk about infringement in a court of law and infringement proceedings in a court of law. So, as you may recollect, Article 4 was quite straightforward. It dealt with good and bad trademarks. But Article 5 now talks about comparisons between previous trademarks or previous rights. And so you have to look at the provisions of the directive Article 5 very carefully, because in some it is mentioned about previous earlier trademarks, and then there are some aspects about earlier rights, and so these have to be carefully understood, especially in the context of a lot of the issues that arise when we are dealing with a right to a name, a right of personal portrayal, a copyright, industrial property right, etc. So it's quite a wide ranging scenario that is being discussed here. Now you have to remember certain aspects, and then I'll talk about them again. The case law and everything else, the way it has developed, it basically reveals that as far as the law is concerned, the consumer is smart enough and clever enough to know what is right or what is wrong. It all depends on the product that is being sold, and of course when you do such comparisons of conflicts with earlier trademarks, you cannot compare two trademarks side by side, because that will never help. The reason being, then of course, you will obviously make out what are the differences and what are different features, and what are the similarities. Rather, one has to take recourse to the memory. So it's like you have seen a trademark or heard about it, and it's there vaguely, represented in the back of your mind. And now you are going to buy a product, and you see a similar trademark, and now you get confused. So, how would this work out in real life? Now, let's say my my daughter says she wants a particular type of sports shoes, and well, I ask her what shoes are these, and she says, well, she saw them in class, some people were wearing them, and she's 10 or 11 years old, and so she hasn't got a complete idea about this thing, but she does know that it had a figure of a cat on it. Now, that's where the problem starts. So I am a consumer in the sense that I'm buying a product for my daughter, not because I want to, but because she wants me to. And so my interest in this particular product is minimal, bare minimum. I'm not really into sports shoes with images of cats on them. So well, okay, I go to the shop and I tell the shop person that I'm looking for this particular type of sports shoes, and it has a cat on it. And so the shop person says, well, okay, who's it for? I say it's for my 10-year-old daughter. And so the shop person says, well, here are these Hello Kitty shoes, you can buy them. And Hello Kitty is a cat. So I buy them, take them home, and then my daughter gets upset because maybe she had Puma shoes or Sable shoes or some other shoe company in mind. Now I would say, Puma is not a cat, right? It's a mountain lion, it's a cougar, it's a leopard. But yeah, it belongs to the cat family. It's a feline family. So that's how a lot of these problems occur. And so when we look at two different types of trademarks to compare them side by side, there are always these issues that arise. And so that's why when you go to a court of law, you have to bring in evidence from psychologists, from people who are experts in words and phonetics, and experts also in surveys, because you have to conduct surveys to show that a substantial group of people got confused because of a similar earlier trademark, for example. And so this is the gist of it. And of course, when you understand this concept, then you will realize that Article 5 is not just to be looked at from a purely trademark registration purpose, but rather also later on, because if you go to a court of law and you are trying to dispute whether this one is similar to the other one, then you can have all of these conflicts which arise, and they have their roots in Article 5. Now, I remember in Finland there was this Valio versus Ingman case or something, regarding ice creams, and so they had a lot of these fights over what is a milk ice cream, and I have some of those cases put up somewhere as well. So again, trademark case laws are there in the trademark part, but I don't think I included that particular one. But it's quite famous, and a lot of Finns often write about that particular case. So, but these are some of many cases that turn up. Maybe I could even point out to you what exactly that case is, if I can find it. Let's see, there was this trademark case, and yeah, where are we? Okay, just a second. Yeah, Valio versus Ingman, Finland. I believe they had a lot of disputes going on for quite a lot of time, and this was regarding, well, this particular case has been regarding Voi Marini. Yeah, so I'm sure it makes more sense to a Finnish student. But again, yeah, so we have to be careful about these things. So coming now to Article 5, whether marks and goods or services are identical, then you don't have a problem. That's the first part of the Article 5, and that's clear cut. It's identical, and of course, problem solved. Well, it doesn't always work that way though, because you have to see a trademark as a whole. You cannot look at insignificant differences. Instead, you have to look at the big picture, and sorry, based on that, you have to decide whether the trademark is similar or not. So here's the case: Reed Executive PLC versus Reed Business Information Limited, and this is one of the very first cases from 2004, which dealt with meta tags, and and so that's why it's a very interesting case. And what was it about? Well, of course, you can see here there are two companies that are fighting. One is Reed Executive PLC, the other is Reed Business Information. And the claim was that, both of these marks are identical. So what you have to now try to figure out is, how can you say identical? Because, Reed Executive PLC doesn't sound the same as Reed Business Information. But the courts held that the main mark, or the main aspect of the mark, is read, the word read, REED. Now, when you read this case, of course, you will see what it is all about. The interesting aspects are, before the internet era became more predominant, you had employment agency, Reed Employment or whatever, and their job was to help people get a job. So you complete your studies, you apply for a job, and you would go and give your biodata or CV to this company, and they would then try to match you with prospective employers, and that was their business. At the same time, there was another company, Reed, etc., Reed newspaper or something, and what they were doing is they published a newspaper or a magazine. And if you may recollect, there's in the newspaper there's always this one segment which is just about classifieds for jobs, or whatever you want to buy or sell, a car or a house, or you want to get married or something, then you put an ad over there. And so that was the segment which was about job employment possibilities. And both of these companies coexisted. They never had a problem, because if you wanted a job, well, you would go to the employment bureau, And if you wanted to read a newspaper and occasionally see some job advertisements, you would read the Reed newspaper. And so that's how they lived happily ever after. But then came the internet, and that ruined the honeymoon, because in the internet you have meta tags, and usually in the classroom I try to show you how this works. Now of course Google has a more complicated algorithm, and the software, it depends on various things. So it depends on your consumer choices, your what clicks you have been clicking on, websites you've been clicking on, what cookies you have been collecting, and of course, based on all of this, they develop a pattern. And they also have your data from your Facebook and your online, whatever you do. You go to TikTok, or you go to some website, whatever you read. And so based on that, Google now claims that they have this algorithm which sort of tries to get you the best possible ads. And so if I was to type in BMW, for example, chances are on the first page itself, after the BMW official web pages in Estonia, I would get a used car dealer based in Estonia. It wouldn't make sense for Google to show me a used car dealer in Uganda or in South Africa. How would that help me? Instead, they try to show somebody in Estonia or in Latvia or in Finland. And because they know that I'm in the European Union, they don't show me in Russia, because again, Google has the smart system. But before Google's software came out, things were not so straightforward, and search engines charged you money, and if you gave them money, then they put your website up on top. So that's where the problem arose, because these two different companies during the internet era started their own websites. And now how does the website get how do you go onto a website? So very often you go to a search engine, you type in Reed, REED, and it shows you different choices. That's how it would work. Now of course, if Reed Business Information pays more money, then they come up first in the checklist. And if Reed Executive PLC pays more money, they come up first. So a very competitive way of doing internet search engine business. Now remember, this was still late 1990s, early 2000. And so the issue here was, what is the trademark? Now of course there are two important aspects over here. Number one is of course that the trademark is Reed, and both are claiming ownership to it, and the other parts, Executive PLC or Business Information, are just frivolous. Number two is, this talks about meta tags. So this is even more crazier, because a meta tag is like Reed. Yeah, that's the meta tag. You type in Reed and it comes up on the internet, and this is not even visible. So it's an invisible use of a trademark. So again, very interesting things that came out. Of course, from today's standards, if you were to look at this, you would say, oh, this is such a boring, archaic, antique law, because of course things have changed so much right now. But very often you have to see how these things play out, and so the historical background often helps. Then there is this similarity aspect. Yeah. So first one was identical. Identical is the easy part, but nobody is stupid enough to copy and paste, yeah, or cut and paste. Why would people do that? Instead, everybody, of course, tries to come up with something similar. All right. So now, what would be similar? Well, you can have all sorts of um, different sounding trademarks which still somehow have some similarity in them. And this is very often the case with a lot of these disputes. So one of the case laws over here is Sable versus Puma. And again, you see, it's very interesting because there are no words or names over there, but rather a depiction of two different types of animals. So one is a depiction of a puma, this mountain lion, or this cougar, leopard, jaguar, whatever you call it. And in northern parts, it's I think the closest of it would be the lynx, yeah, Ilves as it's called in Estonian. So they are all part of this subgroup, and that's the puma. And so they have this representation of this very thick, tough looking feline that's jumping. Yeah. And Sable, on the other hand, had the representation of a running cheetah. Now, both of these belong to the feline family. From far, they look like cats. Yeah. So, what is being assumed here is, you see an ad on TV, you see some photographs on Facebook, and you see this, this animal which looks like a cat. It has a tail, it has four legs, and it has a face like a cat or a feline. And so you have this idea that, okay, I want this particular type of brand trademark, and then it turns out that you get confused because a cheetah also looks the same if you are looking at it from far away without specs, little drunk. Well, it depends, of course, on a lot of aspects. What is your psychological state of mind when you're buying something, and what are you really thinking about? And you see, this goes back to much older times. Some of the earliest case laws from 100 years ago were, you had these chocolates, small little chocolates, yeah, like a toffee or something, and it was always in red paper. And so the red became synonymous with this company's products. And so when somebody else tried to sell their chocolates or confectionery or toffees in a red colored paper, then the first you know seller producer sued the second one and said, no, you can't do that because red is my color. And you would say, how does it matter? But yes, there's no name on it. And of course, this is a product which is for children who are less than 5 or 6. So they only maybe understand it in the context of colors. Or maybe there are people who are not educated. Now remember, this was 100 years ago as a case law. So already the first instances of people, traders trying to monopolize certain trademarks or color schemes or labels, can be seen here. So this is a very interesting case about confusion, and you must consider this in the context of the eyes of the average consumer. An average consumer is a person of average intelligence and imperfect recollection. All right. Of course, you may say that nowadays consumer behavior is not the same, because if I want a product, I have a smartphone and I can just access the website, or I can take a screenshot or whatever, and then show exactly that image to the salesperson. So the risk of having any problems regarding confusion or deception get considerably reduced. Yeah, but it's not always like that, because I remember I always get these razor blades. So you see sometimes I'm like clean shaven, sometimes not. So these are these Palmolive razor blades, and they come in a blue packaging. And I was in Rimi some time ago, and I was in a rush, and I was just going through, and I said, oh yeah, I need some razor blades too, disposable ones. So I just picked up this blue package because it was on sale, and I said, yeah, that should be good. And then later I tried to shave, and it wasn't the same quality, and that's when I checked and I realized it wasn't Palmolive. It had the similar blue color, but it was some Rimi special razor blades, and I felt really stupid about it, because I mean, here I am, a trademark lawyer, talking about trademarks, trade names, color schemes, get up, layout, intricacies, insides and outsides. And even the thing is, that stupid packet was 2 euros. Who cares? It's just 2 euros. So you don't even really look and notice each and every aspect about it. Now, this is of course very different from somebody who's buying a Maserati car, because this person would know obviously the difference between a Maserati or Bugatti or Ferrari, because it's not just silly Italian names with end with E in the end. No, it's got a meaning for it. It's got a history for it. It's a statement you're making. You're buying a car that's worth 70, 80, 90,000 euros. You better keep your eyes open for this. So of course, a lot of these issues do arise. Now you may say, well, so what's the big deal? Sable versus Puma. Somebody got confused about a shoe. Well, the problem here is, because of this confusion or deception, somebody lost out on a sale and somebody gained on a sale. Now, if this can happen, say, to 10% of consumers on a regular basis, you're talking about 1 million lost sales just because of these issues. So this is something to be paid attention to, and it all depends on the nature of the goods or services, their end users, the method of use, what's the competition, is it competitive, is it complementary, and then all of these are very important aspects. Now, an example of how this could be relevant even in the context of a different language would be like in Estonia, you don't have an Apple store, not an original Apple store. You have, you have other things, but not an original Apple store. So one of the dedicated resellers, yeah, reseller is Valge Klar, yeah, and so okay, they are Apple resellers, so they sell Apple products, but these are not sold directly from the Apple factory, but they are bought by the reseller, and that's why you have an Apple phone that costs 50 or 100 euros more in Estonia than it would cost in if you were to buy it from an original Apple store. And now, well, in this sort of a situation, I'm talking about a physical store, not online sales. Now, if you were to look at this aspect, if you really start thinking about it, well, Valgeklar is a type of apple breed, which is, not a breed. Breed would be more for animals, but a apple subclass or species. And it's quite popular in Estonia. People plant these apple trees in their gardens, and they get nice juicy apples. And it's called Valgeklar. And you have different types of such names. I have a few. Valgeklar, then there is August Vaga, and Ovaba, and all sorts of different names. The same even like goes for roses. You have Yosemite Falls, and then you have Rita Usma, and all sorts of crazy things. Yeah. Well, one thing this coronavirus taught me is gardening, because I spent a lot of time in the garden last spring and summer. So, and seems it's going to be like this year also. But now coming back to Apple and Valgeklar, yeah, now you see the connection. You see, it's a little secret Estonian secret joke which many of us may not have understood initially. But Apple, the company that sells iPhones, has an Apple logo, and Valgeklar is a type of an apple, a very very preferred type of apple in Estonia. So you can see how this plays out. But of course, if you do it cleverly in a smart way, nobody gets confused. Then of course it's not a problem. Nobody's going to buy €1,000 Apple iPhone and get confused with something that is being sold or repair services are being offered in Estonia. So again, there are a lot of issues that come up with this, and we have to be careful about this. Now, historically, there have been some cases about these situations, about similarity, and I've given some examples in the past. I think out of my own head, Hess Burger versus His Burger, yeah, or His Burger versus Her Burger. These sort of things can often come up. Then, of course, you can have similar goods or services. Now, in the next lecture, probably I'll be talking about different classes and classifications, and so you'll get a more better idea about the practical aspects about trademarks. Right now, we are still talking about very theoretical issues. So, what are similar goods or services? Now, in this regard, wines are similar to whiskey and bar services. It makes sense because they're both alcoholic. Of course, you could have non-alcoholic drinks. You could have a children's champagne or something, but it would not be placed in the alcohol section of a departmental store. Now, of course, again over here, you have to remember that over a period of time, people's and consumers' expectations have changed. So earlier, you would have a dedicated alcohol store, or you would have a dedicated bar, where you go to get drunk. But now that's no longer the case. You have a food court, you have different shops. Maybe you have one big Rimi or Maxima or Prisma or Silver, and they have a dedicated alcohol section somewhere. So the same even goes for alcohol. You can get alcohol in a restaurant. So of course, when you look at these issues, you have to be careful about what are similar goods or services. So Johnny Walker, well, you automatically figure out that this is alcohol, right? Johnny Walker does not go with Burberry. Yeah, no, of course not. They're completely different aspects. So milk and cheese, again, they come, in the same family. They come from milk, lactose products. They come from a cow. Of course, you could have lactose-free milk, lactose-free cheese. Yeah, but now getting a bit confusing sometimes. So footwear can be similar to clothing because very often they are sold in the same places. Yeah, and they are worn, together, of course. So why is this relevant? Because you can have a situation when we're looking at what is similar and what is not similar, and you're not just looking at the trademark, but you're also trying to understand what is the trade channel through which this trademark product would be available. Why is that important? Because there's a case of Mercedes, and Mercedes is a car manufacturer, and it's also known as a Merc, yeah. And then these are expensive German cars. They sell for 50,000 plus euros. And then, of course, on the other hand, you have there was this case where there was this man who was making white cotton T-shirts, selling them for 5 euros, and his trademark was Merc, MERC. Now, would you say that these two trademarks are similar? Yeah, well, Mercedes Merc for the car and Merc for the T-shirt, they do look quite identical actually. But the question now is, which person in his or her right mind would think that this white cotton T-shirt with the name Merck on it came from a German automobile factory? Yeah. But of course, you do also have to consider other aspects. It could be that sometimes you have merchandise that is sold. Yeah. Now this makes a bit of a problem here, because when you go to McDonald's, it's not just about the food, but you can also get a Happy Meal, which means you can get toys. Yeah. So that's an issue. You can also get maybe a McDonald's balloon. Maybe you can get a McDonald's T-shirt with a clown on it. So of course, there are no hard and fast rules over here. That's what I'm trying to say. But goods or services which are not similar, if you were to consider these, now remember we are looking at earlier trademarks and the similarity or the confusion, deception that can arise. And so it was held here that alcoholic beverages are not similar to coffee. That makes sense. Although there's a distinction made with beer, because beer is not really seen as a heavy alcoholic beverage. It's more something you can just have on the go. So of course, milk products are not similar to animal food products. So again, animal food products are not similar to human food products. Yeah. So all of these play a very important role in our understanding of what is similar and what can cause confusion, and in the context of an earlier trademark or a trade right as such. So this is of course quite straightforward and simple. Another issue that would be here is we have to study the economic behavior of the consumer and how it would be affected by something like this coming in the market. And of course, if you can have sometimes problems in the sense that McDonald's, the restaurant people, they tried to stop somebody in Scotland from using the trademark McDonald for their restaurant. So somebody in Scotland was using the trademark McDonald for some bar or something. And McDonald's, the American restaurant chain, they tried to file a lawsuit in the UK, in Scotland, against these people. And then it turned out that in Scotland the name McDonald is very common. It's like McDonald, McPherson, McGuinness, whatever. It is Donald, and Donald's son is McDonald. Now, in this particular situation, the other side, they brought a phone directory. I used to have these in the past. And if you look at the phone directory, it has the names McDonald and 100 pages. Everybody is a McDonald in Scotland apparently. And so this guy was using his own name. So in that case, of course, he or she has a right to use their own name. And in that case, McDonald restaurant people could not stop them. But again, no hard and fast rules here because you can have different circumstances. And that's the thing with law. Just when you think you have all the answers, it turns out that no, sorry, you don't have all the answers. There is, of course, an aspect over here to be considered, which is an unfair trade practice or an unfair advantage. And this is where the concept of free riding comes in. And basically, what's happening here is that a product has a reputation, and then of course, it may be for a different category altogether, but you can have problems, and especially in that context, if it's a well-known trademark, it comes in over here. And this is seen in the context of what you call trademark dilution. Now, an example of this would be, for example, let's say, all right, champagne. Champagne brings up a lot of emotions. Yeah, it's expensive. If it's genuine, of course, it has to be from France. And there's a difference between champagne and just bubbling wine, bubbly wine. What the hell? Yeah, they're not the same. They're obviously very different. Similarly, you could have a situation where Scotch whiskey comes from Scotland. So if you have Johnny Walker Black Label, that's already 60 euros a liter. If you have Johnny Walker Blue Label, that's 200 euros per liter. Then you have all of these, different Scotch whiskies, single malt whiskies, and they all have built up a reputation. It's important because sometimes people think, what's the big deal? Well, it is a big deal. When I go to buy a Scotch whiskey, I don't want to buy something made in Moldova. What the hell? Moldova is not in Scotland. When I want to buy cognac, I don't want to buy it from made in Sarema. What the hell? Cognac is not supposed to be made in Sarema. So what we are looking at over here is a trademark dilution, and this is a very problematic issue for trademark owners, as you can imagine. And so when we are comparing Article 5 and the similarity and confusion that can arise, especially in the context of well-known trademarks, then you have to understand it in this context. Basically, it just it sort of provokes an adverse reaction, upsets the customer, and because of that, it is bad for reputation. And if it is bad for reputation, then of course you have a right to sue whoever is misusing your trademark. So you started using the trademark and you call it mango. Yeah, now this used to be quite popular 40 years ago, 30 years ago. And then of course it was registered as a fashion trademark, and it was for fashionable products for young fashionable women. And then somebody started manufacturing helmets, helmet what you wear on your head when you're riding a motorcycle or a cycle, and they called it mango. And then of course this caused problems. But on the other hand, there was Kinder Care, and Kinder Care is quite similar to your Kinder chocolates. So again, there was this issue with regard to whether this can cause a problem or not. But in that case, it was held it's okay. There are also other cases. I have put up recently some more modern cases. There is this case on the Lindt bear. Where is that? Should be here. It's supposed to be in this particular case here. So there's Kit Kat versus Quick. Again, quite similar, not in the context of the word as such, but more about the representation of the design of the product. And then there are these cases, like for example, there was another case of IKEA versus Nikea. So IKEA, we all know, all right. IKEA is the Swedish brand, and of course this is make yourself type of furniture. So Well, of course, if you've been to an IKEA store, they also have a little cafe area where you can go and sit down. You don't have to go to the shop just to buy something and get out. You can go look around, think, go up to the cafe, order IKEA meatballs, have some coffee with it, something sweet, and then come back and buy whatever you want to buy plus extra anything else. So this was the whole idea, and now somebody came out with the trademark Nikea, Nikea. So now, of course, when you are doing a comparison, you have to be very careful over here because there are quite a few aspects about this to be aware about. So your trademark is IKEA, and you can see that here, IKEA, and then there is Nikea. Now if you were to look at it, IKEA itself is IKEA, right? So that's 3 syllables, and Nikea is Nikea, so again 3 syllables. The only difference here is that Nikea has the alphabet N in front, yeah, which sort of goes quite okay with I, and so it becomes a bit soft. And the prefix is a bit different, just a bit, yeah. And the suffix is Kia. So Kia again is quite similar. So now the difference also is one is 4-lettered and the other is 5-lettered, which is again not such a big difference. And so you have a lot of these issues that come up, and even when you look at infringement of trademark later on when we discuss it, you will have the same issues coming up. Wagamama is this British fast food chain, not doing very well nowadays though, and I don't know if you've been to the UK, you will have come across it. And then some Indian guy started a similar restaurant sounding with a similar name, calling it Raja Mama. So you have Wagamama and Raja Mama, and then of course a lot of these cases are quite interesting because what they reveal to us is this whole concept of how your trademark itself is not bad, it's just causing a conflict with a previous trademark. So somebody got it before you, and now because of this problem you have to suffer, simply because, well, first come first serve. Now this can of course often cause a lot of issues, but these are the two main fundamental articles, Article 4 and Article 5. If you spend your time reading about them, even let's say in a good book that would be 150 pages or something, all sorts of case laws, it often gets very confusingly similar to the chapter on infringement, because very often how this goes is you have a trademark office, and you're applying for a trademark, and of course you have the similarity issue. But even if it goes through somehow, then this matter will obviously go into court of law as well, because you have two very different trademark owners who have a similar or an identical trademark. Now, although it's not here in a directive, it is possible for two similar trademarks or an identical trademarks to be in together, and this is a possibility in the sense if both sides agree, then of course you can agree to coexist, and we'll look at some of these issues in the next lecture, because I'll be explaining more about how trademark is a form of property, how it can be sold, how it can be used in different ways. So you can have Stockman Tallinn, very different from Stockman Helsinki, and also the reorganizations that arise when you look at trademarks as property, and also the tax implications and all these problems that can come up. So enough for today, and we'll catch up again next week. Until then, goodbye.